All right. Good afternoon, everybody. Welcome to today's webinar. This is Mike Fielding. I'm a partner in Husch Blackwell's Insolvency Group, and I am a member of the firm's Food and Agribusiness Unit. I have a few housekeeping matters that we're going to go over while people are logging in as part of the technology process. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any question during the webcast, please submit it via the question box. We'll try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, we will answer it via email. There is a PDF presentation available in the resources folder. For those that are attorneys, this program has been approved for legal education hours. To report your hours, you will need to click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And so that's all the housekeeping matters that we have. Now we get to turn to the main show, the fun stuff here that we're going to deal with today. Co-presenting with me today is Yana Vladimirova. Yana is a senior associate in our Madison, Wisconsin office. She also has the honor and distinction of being one of the Subchapter V Trustees that are newly installed as part of these small business bankruptcy filings. Just a quick note before we jump into everything. This webinar is part of a quarterly webinar series that we have been doing, dealing with issues impacting distressed loans. Our next quarterly webinar series, in case you're interested, is going to be on December 8th. It's going to be myself and Stephanie Kaiser out of one of our Texas offices. And we're going to be discussing resolving distressed agricultural loans. We'll be getting into what I call loan renewal season as far as ag loans. And we know 2020 has been a pretty brutal year for farmers for a variety of reasons. And we anticipate that there's going to be a need for some practical guidance dealing with those distressed loans. So with that, let's get started. Today's agenda is going to really be split into two parts. Part one is really an important foundational review of the Small Business Reorganization Act, the changes that occurred to the Bankruptcy Code. Part two is going to be creditor strategies. Yana's going to cover part one, and then I'm going to cover part two with candidly a pretty big emphasis on these creditor strategies from the perspective of secured lenders. Just to kind of preface all this, two key items. One item is I was looking at some reading in the last few days, and it is estimated that when this new Bankruptcy Act was passed, that the approximately 40% of Chapter 11 filings since 2007 would have qualified under this new act. And so there is a potentially really big impact on lenders in particular from these new provisions. The other interesting thing, I was looking at some statistics from the American Bankruptcy Institute, and since April, these small business bankruptcy filings are up about 106%. So obviously, the surge has been anticipated, and so far we are seeing that surge. One final point, and this goes to the continuing legal education credit. Some of the states require that there be poll questions during the process. We do these poll questions, frankly, because it's kind of fun to see what the feedback from the audience is as well. And so as part of doing that, we have our first poll question. This is just to see if you're there. What you'll need to do is just click an answer on the screen, and we'll have 4 of these during the presentation. So the first question is, how long do you think COVID-19 will adversely impact your business? The questions are 0 to 3 months, meaning the next 3 months, 3 to 6 months, more than 6 months, or not applicable. COVID-19 has actually been really good for business, and there are actually a few companies that is definitely true. So go ahead and submit your answers, and we can click over here, and you can see from the results a big majority of people here today are thinking that this is going to drag on for longer than 6 months. I personally fall into that camp belief or that mindset as well. I think this is going to have a big impact on the economy also. So with that, let's get started with part 1. Jana, I'll turn it over to you.
Thank you, Michael, and hello, everyone. So we'll start with an overview of Subchapter V bankruptcy proceedings. The Small Business Reorganization Act was enacted a little over a year ago, but really has been in effect only since February of this year. The law, which was the result of bipartisan and bicameral action, a rare event nowadays, effectively added a new subchapter to Chapter 11, Subchapter V. Which aims at addressing a long-standing problem with small businesses, which in the past not only did not succeed in Chapter 11, but avoided filing Chapter 11 altogether. And this was because, given the relatively simple capital structure of most small businesses, filing a Chapter 11 often resulted in a loss of ownership by the very shareholders or interest holders who had often founded the company. And who currently manage the company. And the reason for this result was that regular Chapter 11s have what is called the absolute priority rule, which I'll discuss later on in more detail. But in essence, the rule provided that if equity holders do not pay their debts in full, they could only maintain ownership interests with the consent of all their creditors by making a considerable contribution of new value. Meaning fresh new money from outside of the business, which is something rarely available, especially to small businesses. The Small Business Reorganization Act basically fixes this problem through the debtor's voluntary election to be treated as a Subchapter V debtor. And of course, certain other conditions being met, which I will also discuss later on. As we will see, the SBRA makes it easier for a variety of reasons for small businesses to seek Chapter 11 bankruptcy protection. So the original debt eligibility under the SBRA was about $2.7 million, which made some insolvency practitioners and commentators wonder how useful Subchapter V will really be. The recently enacted Coronavirus Aid, Relief, and Economic Security Act, which is also known as the CARES Act, includes key provisions to provide financially distressed consumers and small businesses greater access to bankruptcy relief. And among these key provisions was an amendment to the SBRA to increase the eligibility threshold for small businesses from filing under Subchapter V from $2.7 million of total debt to $7.5 million. This increase is set to expire on March 27, 2021. So there is a huge incentive for small businesses to file before the law changes. And of course, some believe that the change in the law may be extended further on. But we don't know if that will really happen right now. There hasn't been any indication from Congress on that front. So what is new and unique about Subchapter V? A few things, all of which are geared towards making confirming a plan cheaper and faster. First, unlike regular Chapter 11s, in Subchapter V, the court has to hold a status conference within 60 days of filing the bankruptcy. The purpose of the conference is for the court to be able to pinpoint any issues which would prevent the debtor from proposing a plan within 90 days of filing, which is also a new requirement under Subchapter V. Compare these to regular Chapter 11s, which have generally no time limitations for filing a plan except for the exclusivity period, which allows the debtor the exclusive right to file a plan in the first 4 months of the bankruptcy filing. And unlike regular Chapter 11s, only the debtor has the right to file a plan in Subchapter V. Other differences, there is no creditor committee required in Subchapter V, no disclosure statement, and no quarterly United States trustee fee. It is also much easier to confirm a Subchapter V plan. That is because the court can confirm a plan even if all classes of creditors reject it. The court needs to find that the plan does not discriminate unfairly and it is fair and equitable as to each impaired non-consenting class. Also, unlike regular Chapter 11s, administrative expenses are paid during the plan, not at confirmation. And the debtor only has to pay disposable income to creditors for a minimum of 3 years and maximum of 5 years to receive a discharge. The debtor also retains ownership of the assets, and as I already mentioned, the absolute priority rule does not apply, which means that there is no requirement for the debtor to pay its debts in full before being able to retain ownership. And now it's time for another poll question. So in the next 6 months, do you anticipate small business bankruptcy filings will increase, remain flat, or decrease? And there are 3 possible answers: increase, remain flat, or decrease. And I'll give everyone 20 seconds, and then we'll switch to the results. Okay. All right, 97% of you think that they will increase. I tend to agree with that as well. And in the past, it's interesting, no one thought that they would decrease because in the past few years, we've actually seen bankruptcy filing decrease from 2008 levels. Okay, moving on to the role of a Subchapter V trustee. As Michael mentioned, I was recently appointed to serve as a Subchapter V trustee. So this is a new role for me, and I'm learning as I go, and everyone else, as there isn't that much instructions for what Subchapter V trustees are supposed to be doing. But it is important to emphasize that this is not an operating trustee. Again, this is the debtor in possession bill, and the trustees, they are largely to supervise the restructuring, to review the debtor's financial information, to make recommendations to the court as appropriate, and in general to assist the debtor in complying with the plan requirements so that the creditors get paid. In that respect, the role of the Subchapter V trustee is more similar to Chapter 12 and 13. The difference is that the trustee's primary function in the Subchapter V is to facilitate the development of a consensual plan. So in a way, the trustee serves as a mediator between the debtor and the creditors and tries to get everyone to agree to a consensual plan. Trustees are also to keep the debtor's cash payments until the plan is confirmed or denied. How can Subchapter V be used against creditors? In many ways, particularly because, as I discussed, plans are easier to confirm and the debtor can do so over all classes of creditors objecting. First, Subchapter V debtors can pursue bankruptcy avoidance actions directly, such as preference payments made to creditors within 90 days of filing and fraudulent conveyances. Debtors can file Subchapter 5 if more than 50% of the debt is business related, which would include situations where the debtor was a guarantor to a business debt. And perhaps the most significant weapon individual debtors have against creditors in Subchapter 5 is the ability to modify mortgages on their residence, which is something not generally available to debtors in the other bankruptcy chapters. Of course, there are a few requirements in order for debtors to be able to do this. The primary purpose of the loan could not have been to buy a home residence. The primary purpose needs to still be to run a business. For example, I currently have a case where the property in question was purchased to be a bed and breakfast, but the debtor also, it's also the debtor's residence. And so for that reason, the debtor is able to modify the terms of the loan. And another requirement to be able to do that, the loan proceeds must be used primarily in connection with the debtor's business. What remains the same in Subchapter 5? The automatic stay remains in effect, which basically prevents creditors from attempting to collect from the debtor upon filing of a bankruptcy. Debtors are still required to make adequate protection payments to secured creditors. Debtors in possession, which means that business goes as usual. The trustee does not have an operating role, so it's still the debtor operating the business. Debtors in possession who need financing after filing need to seek court authorization, just like in regular Chapter 11. Sales under Section 363, free and clear of liens and encumbrances, is still possible. The debtor can assume or reject executory contracts. And finally, exceptions to discharge under Section 523, which provides basically a list of debts that cannot be discharged, including debts incurred as a result of fraud, still apply in Subchapter 5. So who is eligible to file a Subchapter 5? This is a person engaged in commercial or business activity whose total aggregate non-contingent liquidated debt is not more than $7.5 million. And from that amount, it's excluded debts owed to affiliates or insiders of the debtor are excluded. And of course, at least 50% of the debt must arise from commercial or business activity. So this subchapter primarily applies to business debtors. And who is not eligible? Debtors whose primary activity is the business of owning single asset real estate would not be eligible. This is not considered sufficient business activity under the statute. And also affiliates of the debtor who cannot individually meet the Subchapter 5 requirements also are not eligible to file under Subchapter 5. And now it's time for another poll question. Do you believe small business bankruptcy filings will adversely impact your company? Yes, no, or I don't know. And I'll give you guys a few seconds. Okay, we have more varied results on this one. 65% of you believe that they will adversely impact your company. 23% believe they won't, and 10% of you don't really know. It's an interesting question, and it's hard for me to even say whether they will adversely impact creditors. On one hand, small Subchapter 5 allows for a very efficient way to file bankruptcy and get out in quickly and cheaply, and in a way, it saves creditors money as well, and it's very predictable what can happen. On the other hand, as I mentioned, creditors' rights can be significantly modified under Subchapter 5. So this can effectively adversely affect creditors. And how exactly creditors can avoid that, or what strategies available to creditors, I'll turn it over to Michael to discuss in the next section.
All right, thanks, Yana. And just before I dive into creditor strategies, a few of the folks listening today have asked a few questions. I've individually answered them, but I think it'd be good just to quickly throw these responses out to the group as the whole. One of the first questions that came in was asked about whether or not these Subchapter 5 cases just apply to individuals. The short answer is it applies to both individuals or companies. So as long as you meet the eligibility requirements, doesn't matter if you're a human being or a legal entity, you can still file. The next question was on the $7.5 million debt limit. Is it secured or unsecured? The answer is it is the composite or the aggregate of all the debts. Now, again, these are the contingent non-liquidated debts, and I think there's that important caveat. When you look in a statute, it excludes debt owed to one or more affiliates or insiders. So theoretically, when you're doing that calculation, you know, the company could theoretically have more than $7.5 million of debt, but if it's just to insiders, they may be able to make the argument that they can, you know, get in under the cap. Another question was, how does the Subchapter 5 trustee get paid? The short answer is it's going to be typically an hourly rate, but it has to be approved by the court. So just like any other professional, they have to file a fee application with the court and get it approved. And one of the other questions that came in was how much does a small business bankruptcy cost? And the person that posed the question said they had thought they had heard $75,000 to $150,000 for the debtor. My response to that is the cost is really going to be driven by how contested the bankruptcy is. So personally, I think most bankruptcies from the debtor's side would not get that expensive. But if it is a contested proceeding where there's, you know, a lot of bickering back and forth between different parties, you could certainly see the debtor's fees easily getting into that range. I've seen that we have a few other questions come through, but what we'll do is we'll get plugging along here with the strategies portion of the presentation, and then what we'll do at the end, we've allotted for about 10 minutes of Q&A, and we'll do our best to answer those questions. So keep firing away. They're not being ignored. We'll just get to them here towards the end of the presentation. All right, so when we talk about creditor strategies, the first thing I want to emphasize here is that this is a really brand new area of the law, and there's very little case law that's out there, and the little case law that is out there is really talking about, you know, people that were in Chapter 11 and then wanted to essentially switch to this Subchapter 5. So it's kind of interesting on one hand, but as a practical matter, it's not really going to apply to most of us. I think it's important to realize that because this is a new area of the law, and because we are anticipating what I think is going to be a big surge of small business bankruptcy filings before March 27th of next year, we're going to see a lot of people trying to look for analogous situations. And when you really start comparing Subchapter 5, candidly, the best analogy, or what it's most close to, is Chapter 12, but it's not a complete mirror of Chapter 12. There's certainly some Chapter 13 elements blended in there, and then there's obviously some big parts that are still from a normal Chapter 11 that are going to apply. So you're really drawing on elements from these three different areas, and I think when it comes time to trying to evaluate how courts are going to look at it, they're going to look at, okay, what is most analogous in these three other areas, and we're going to draw from that. So the first part is just a general strategy for all creditors, and candidly, the strategies that I've put up here on this slide are really strategies for a contested hearing. You'll hear a little bit later that I'm a really big fan of seeing if you can get something consensual, because I think it'll be cheaper and faster and frankly much better for creditors in the end if you can do that. But if you're in one of these contested scenarios where it's just a bitter, ugly situation with the debtor, how are you going to challenge them? Well, obviously the first point is you want to challenge eligibility of the debtor. You've got this $7.5 million cap that's going to apply. It's important to emphasize that 50% of that's going to have to come from the commercial or business activities. Now, if you have a single asset real estate debtor, they are not eligible for this Subchapter 5. So that's a really important caveat. So maybe you have kind of a small one-off hotel, or maybe you've got somebody created an LLC that owns some commercial real estate, or as probably every lender has, they've got somebody that bought a restaurant, right? And they own the restaurant, they releasing it to the restaurant operator, and obviously that's gone dark, so that's going to be a troubled loan. Well, if that's a single asset real estate, where it's essentially one piece of real estate, and that's its main operation is to get rents from it, they're not going to qualify. So eligibility is a big point to challenge it. Another key area that I need to emphasize here too is when you look at guarantees, because a lot of times you'll have like an LLC. This is obviously very common for a lot of small business loans. You have the LLC is the operating entity, but then you've got the owner who has signed the personal guarantee. And the question is, can the owner file their own Chapter 11 bankruptcy, even though they're not, the business, but they have signed the guarantee? And the courts, right now there's a leaning or an inclination that is, listen, if 50% of that individual's debt is affiliated with a business, then yes, they're going to be eligible for this. And that's a pretty big deal, because there's a ton of small businesses out there where the loans are guaranteed by the owners. And so you could be faced with a situation where the business could go into bankruptcy and also the owner, or you could be faced with a situation where the business is defunct. Maybe you've even liquidated the assets, but the debt that the owner has on the guarantee arises out of a business operation. And right now the courts have been leaning a little bit towards the conclusion that, yeah, they can file and they can take advantage of this. Next bullet point is, how do you seek the removal of the debtor for cause? Well, cause, when you look under the statute, it gives a list. It talks about fraud, dishonesty, incompetence, gross management, and it says either before or during the bankruptcy. Well, I've spoken to enough loan officers that they're just kind of banging their head against the wall saying, oh, I'm so tired of this debtor. They're just so incompetent. Maybe they sold stuff out of trust. And I get it. I feel your pain. A lot of people have been there. The question is, will it arise to the level to where you can get the case dismissed or get a trustee put in possession and frankly get some new management? Well, obviously that's going to come down to the judge. It's a tactical decision. I will say that as a practical perspective, if you are if you're representing the bank, you really need to document your file so that if you decide to go into court, that you can really make a good case that there truly has been fraud or mismanagement. So if, like for example, if there were sales out of trust, right, that's a very common situation. You want to be able to document that as best you can to essentially go in and run into the judge and say, listen, judge, this debtor, this operator cannot be trusted. They've got a history of doing stuff fraudulently, selling out of trust. we don't think anything's going to change in bankruptcy. If you do that, if you've documented it well, you'll have a little bit better chance of getting it possibly a trustee appointed, or possibly a conversion or dismissal. I will say though that just my own personal experience with those motions, because I've attempted that in the past for past clients, judges tend to be a little bit skeptical of it. They're like, man, what, the past is in the past, and we're going to give them their fresh opportunities. So that's kind of the inherent, I don't know if I want to say bias, but there's, I think, a judicial leaning towards giving the debtors a chance. You can also, obviously, as I put here at the bottom, you can seek to dismiss or convert the case. Again, you're going to need to get cause to do that. All right, let's talk briefly about unsecured creditors, and then we're going to do a big focus on secured creditors. So if you are an unsecured creditor, obviously, and this is just good general bankruptcy advice as a practical matter, is put the, whoops, we got a typo there. I said put the creditor on cash in advance terms. That's obviously a typo. It's put the debtor on cash in advance terms. And let's put yourself in the shoes of a lender, right? Once the bankruptcy is filed, this borrower of yours has really, frankly, made a bit of a living of just buying goods and not paying people for it. And now suddenly, if they are put on cash in advance terms by most of their vendors, which will happen, that's going to really strain the debtor's finances. So as a lender dealing with a debtor, especially if you're going to be doing debtor in possession financing, you need to think about how's that going to impact the performance of the loan, right? So when they file, and just make the assumption that, say, 80%, 90% of all the vendors that they're dealing with are going to put them on cash in advance terms. If that's the case, can this debtor still cash flow? It's a really important question, because if they can't, right, if they can't cash flow in bankruptcy, then there's a serious question about what you as a secured lender would want to do. Now, if you're an unsecured creditor, you want to assert what's called a 503b9 claim. What that means in layman's terms is if you've sold goods within 20 days before bankruptcy, you got to get a claim submitted for that, and it will be treated as an administrative expense claim. The reason that is so critical to do that is because you've got this gap period of time between when the case is filed and before the plan is confirmed, right? And that could be a few months, it could be longer. And the debtor, under these new bankruptcy amendments, the debtor does not have to make payments to the trustee. There's no provision in there requiring it. So if the debtor gets in there, kind of flounders around, doesn't get a plan converted, and then the case is dismissed or converted, what the code requires is that the monies have to be given back to the debtor, except for payments to secured lenders for adequate protection and payments of administrative expense claims. So a key point here is that if you're an unsecured creditor, frankly, you want to get your paw in the pot, so to speak, to make sure you get your dibs on the little bit of cash that's there so you can get paid for it. Obviously, unsecured creditors need to assess their potential preferential transfer exposure. Those are the clawback actions for monies paid in the 90-day period of time. Don't know, we just don't have much history to see how aggressively debtors are going to pursue those claims. Obviously, unsecured creditors need to file their proof of claim. And then a really key issue here, which is going to play into our next slide, is unsecured creditors need to essentially look at themselves and say, okay, I'm in this pond. How big of a fish am I, really? Because if they are a really big fish in this pond, so to speak, then even though they're an unsecured creditor, they can still potentially influence how things play out in the plan. If they're just a very small fish in the grand scheme of things, really not going to have much weight. I think a good analogy right here to all of this is, when we look at kind of like the mega Chapter 11 bankruptcies, if you're an unsecured creditor, I make that akin to voting in a national election, right? Yes, your vote counts, but as a practical matter, it doesn't count for much. But if you're voting in a local election, then yes, your vote counts, and frankly, it carries a little bit more weight. I think that same analogy applies to these small business bankruptcy cases. All right, now we got to get to our next poll question. And do you anticipate being a secured creditor, partially secured creditor, unsecured creditor in anticipated small business bankruptcy filings? Or the fourth answer would be not a creditor. So just get a feel for our audience here today. Go ahead, select the answer that best applies to you, hit submit, and you'll see here what our answers are. Got a good mix here. You know, we've got over 50% would be secured or partially secured. Got a good group, almost a third, that would be unsecured as well, and then 20% that wouldn't be a creditor but are certainly interested in it. All right, so that's good to know where we stand. All right, this next slide, this next part is really important. So if I haven't put you asleep yet, please wake up, or if I have put you asleep, I should say, please wake up, please pay attention to this slide and everything I'm going to say on it. There is two ways to get, there are two ways to get a plan confirmed in these Subchapter 5 cases, and it's this 1191A versus 1191B confirmation. And these are the two different sections under the Bankruptcy Code. Now, to get confirmation under Section 1191A, all impaired classes have to accept the plan. That is a really important point. Now, an impaired class is somebody where, you know, they're not getting paid in full, essentially, as like they should. There's something being done. There's a cram down of some sort. The debt's getting stretched out. Maybe it's unsecured creditors, and maybe they're only getting, you know, some percentage on the debt. All right, so you're going to have this group of creditors that are impaired. But here's the kicker, is if a plan is confirmed under Section 1191A, it has a major impact on how the plan plays out. All right, now let's talk about those differences. So first off, if you're under 1191A confirmation, it is going to be the debtor that is going to make the plan payments. It will not be the trustee. In fact, if you confirm under 1191A, the trustee's service is going to terminate right there at the time of confirmation. Here's another big thing that may be a bit of a surprise. We know about the disposable income requirement for 3 to 5 years. That requirement is not applicable in an 1191A confirmation. Okay, that may come as a bit of a surprise. I think it's pretty clear from the law that that is not a requirement, and it kind of makes sense because it's basically like, listen, if everybody agrees that this is what's going to happen and this is how the payment's going to be made, then we don't need to worry about whether or not the debtor is devoting 3 to 5 years of their income to it. Another really important point is that if you get confirmation under Section 1191A, then your discharge for the debtor happens upon confirmation. That's a really big deal, okay? Because it's not waiting like you typically get in a Chapter 12 or a Chapter 13 case where the discharge comes at the end of the plan payments. If you're getting an 1191A confirmation, boom, you get the discharge immediately. Now, the exception is, you know, there's the Section 523 discharge items for, you know, if there's like fraud, defalcation, you know, getting money under false pretenses, conversion of collateral, that sort of thing. You can get that accepted, but as a general matter, you get the discharge. Another really critical point about Section 1191A confirmation is that the automatic stay will terminate. All right, and what happens is once the plan is confirmed under this section, this is locking the debtor into place. The debtor cannot modify the plan. So let's just pause here and think about this for a second, right? So if I'm a secured creditor, and if I'm really wanting to try to, you know, frankly, not have a bankruptcy that just drags on for years, there's a real incentive here to try to see if you can get an 1191A confirmation, because if you can get that, it's like it's like you're getting all your I don't know if all your dreams coming true, but a big chunk of your bucket wish list is happening. You're getting the automatic stay is automatically terminating. The debtor will not be able to modify the plan, and you really get a course of action going forward where you're really not going to be kind of encumbered by the normal issues that you have in a bankruptcy proceeding. So there's a big incentive if you can negotiate, if you can get there, to try to get there because it's so beneficial. Now let's contrast all that with Section 1191B confirmation. Now I listed here that no class of creditors accepts the plan, and that's true. So you could have every single person vote against the plan, and the judge could still confirm it. That's a little bit galling. It's a little bit bothersome, but unfortunately that is the law. Now let's talk about the middle ground. You could have, maybe 4 classes, and maybe just one class votes in favor of it, and the 3 reject it. Well, you get the same answer. You would get the judge could still confirm it. So what happens under 1191B? Well, this is where it's going to be a lot more analogous or akin to a Chapter 12 or Chapter 13. So the trustee is going to stay in place. The trustee is typically going to disperse the funds. These payments have to occur over this, 3 to 5 year time period where they're, devoting their disposable income to the payment of it. The debtor does not get their debt discharged until the plan payments are completed. One thing that's, I think, bothersome to secured creditors in particular is the automatic stay stays in place during this time. So, if you get a default by the debtor, you just can't immediately run out and, collect on your collateral. You're going to have to get stay relief in some form or fashion to be able to do that. And you can get a situation where the debtor can modify the plan, right? So maybe the debtor gets going along, they confirm it over the objection of creditors, they get into the plan, 1, 2 years down the road, then, as it seems inevitably happens, life happens and things go even further south for the debtor, and so they can go in and try to modify the plan. I know a lot of you out there probably have your own horror stories that you can recount where you've been in these situations where the case just seems to have drug on forever. Frankly, I'm dealing with one of those right now as well, but that's the reality of the situation. So with all that being said, with this kind of this contrast between 1191A and 1191B, the next question is, what are some key strategies for secured creditors to take? Now, I want to pause here. The first bullet point talks about negotiating what I call a prepackaged Chapter 11. I want to emphasize and make another, what I think is a really, really important point. I'll give you an example. In the last couple of months, I've read about some ancient wars that happened many hundreds of years ago. And the one thing that was unique in those wars is that the one party gained a very important strategic advantage over their opponent by some nighttime maneuvers. So they would essentially, during the night, move the army to a different location to be in a much better position. And because of that, kind of what I call a strategic sacrifice, or a hinge point in the war, so to speak, it made a huge difference in the outcome. And that concept of looking for key hinge points that are going to dramatically impact the outcome of some proceeding definitely applies in the bankruptcy context. And from a secured lender's perspective, if you say, what are the key hinge points? What are the key areas that if I make kind of this strategic sacrifice, or maybe better said, I put a lot of strategic focus, kind of like a magnifying glass, really focus the light on one key area, what is going to have a huge impact? And the answer to that question is going to be, you need to look at what happens shortly before the bankruptcy and shortly after the bankruptcy is filed. And what do I mean by that? Well, what I mean is that when you as a secured lender, and I should say that I'm assuming in here that when I say secured lender that you are kind of the big dog, the main secured lender dealing with the debtor. The debtor's got some real issues about how they're going to deal with debtor in possession financing, what they're going to do with cash collateral, what their plan treatment is going to look like. And so if prior to the bankruptcy, if your debtor, if you know that, things are just going south and they start using the B word with you, right, the bankruptcy word, you really should start having negotiations with them and see if you can come to some sort of resolution about what the debtor in possession financing, cash collateral protections, adequate protection measures are going to be in bankruptcy. Because if you can do that, and if you can come to an agreement on what those key terms are, then when they file for bankruptcy, what you would immediately have done is that there will be an immediate filing to put in place this debtor in possession financing, this cash collateral, these adequate protection measures. And those measures that are put into place are going to have a huge impact on how the case turns out. And so you want to make sure that you get in there, you get your liens put in place, you get everything lined up like you need to do. And if you do that right, and if you really do it right, what you do is you build or structure this loan in such a way so that it has to be incorporated into the terms of a plan. Then what you're essentially doing is it's like you're steering this big ship. You're really kind of saying, listen, we're going to turn the rudder in this direction, and this is where this big rig is going to go. And it all comes from that little bit of movement, that really focused effort. Now, I know I'm belaboring this point, but I just want to emphasize that is really important. When you look at the big mega bankruptcies and look at the big mega bankruptcies that are really successful, you will find that this is a theme that is always done, all right? They don't just file willy-nilly hoping to get things done with their lender. What has happened is there has been some concerted, focused discussions. They file for bankruptcy with a very well thought out plan of execution, and then they implement it. And that's what you want in an ideal world as a secured creditor, okay? Now, I realize we don't live in an ideal world, right? If we can get these what I call this prepackaged bankruptcy, you want to do it. Little side note right here. When you look at all the literature and everything else on these Subchapter V cases, everybody's like, well, the debtor's got to file a plan by 90 days, and it's designed to go faster. But they overlook two key points. The first key point that they overlook is that once the debtor files a plan, there is nothing in these new amendments that forces the debtor to get it actually confirmed anytime soon. So you could theoretically have a situation where the debtor files a plan, but then the case just drags on for 5 or 6 months while people are just kind of harassing one another and fighting over, this or that. Well, that's really bad if you're the secured creditor, because if you don't have your money coming in, if you don't have things lined up, you can just see your legal fees going really high and not feeling like you're getting much progress there. So you want to try to avoid those situations. I'm just chewing up a bunch of time. I need to pick up the pace. Obviously, another key area that you want to do as a secured creditor is leverage your guarantees. I think another key thing is if you realize that if things are just going to go south, maybe you can't get some sort of reconciliation with your borrower, right? And that definitely occurs. Then prior to the bankruptcy, you as a secured lender need to say, at what point do I pull the trigger, and at what point do I start setting off on accounts, and when do I send out the account turnover notices on the AR? That's a really, really critical question, because if you send out those AR turnover notices before bankruptcy, there's an argument that that is no longer property of the debtor's estate. It belongs to you. And if you as the secured lender have suddenly cut the debtor's cash flow out from underneath it, it's going to have a real hard time getting through bankruptcy if it just doesn't have any liquidity. So again, think through the strategy, be very deliberate, be very proactive about how you approach these items. Another key point, it's the bottom bullet point here. secured creditors need to promptly seek adequate protection once the case is filed. And just like I said earlier about the unsecured creditors on the Section 503b9 claims, you need to get in there so you can start getting those adequate protection payments, because if you as a secured creditor kind of dilly-dally around and don't do that, then you're going to lose out on a few months of possibly loan payments coming in. The case converts, the trustee has to give the money back to the debtor, and if you haven't filed your adequate protection motion, guess what? Cash isn't going to go to you, it's going to go to the debtor. All right. A couple other key points. You want to immediately object to the cash collateral. This is assuming that you have not had successful pre-negotiations. You want to negotiate these key terms. Again, if you can negotiate a Chapter 11 plan with the debtor, especially for bankruptcy, prior to the bankruptcy filing, so that you know what the plan is going to look like and how it impacts you, then when you file for bankruptcy, when the debtor files for bankruptcy, you'll have a good idea how things are going to play out. So in an ideal world, you'll get the 1191A confirmation, but in an imperfect world, which is more typically what will happen, you'll be in the 1191B arena. And even if there's a contested plan, if you as the secured creditor are on board and supporting the debtor, the odds of the bankruptcy judge confirming that plan are going to really increase. Now let me make another comment right here just generally about some bankruptcy strategy. A lot of times you'll find secured creditors saying, well, I've got this right and I can file this motion and I can do that. And that's true, right? But the inherent problem with that is that at the end of the day, you are waiting for a judge to rule on something. And as we all know from experience, judges, there can be a lot of delays in getting the ruling. And even when there are times when, we know we're in the right, the judge may not go our way. So because of that uncertainty, frankly, if you're looking to minimize your fees, minimize your expenses, try to get more certainty, sometimes it helps to try to get some sort of compromise, because a compromise will mean it's going to be fast, it's going to be immediate. And if you get a compromise deal that the debtor signs off on and then the debtor later reneges on that, if you then go into court, the judge is going to take a lot more stern look at the debtor and be a lot more willing to put the hammer down on the debtor, because they've essentially breached their consensual plan or arrangement that was reached. Another key issue a couple key issues I want to point out here. This will sound a little bit bad, but there's some reality in it. Typically when you're negotiating with debtors counsel, they're going to want to carve out for their attorney's fees. And lenders hate that, right? Why should we pay their fees? And I get it. I completely get it. But here's the thing that sometimes people overlook. And this, again, sounds a little bit bad, but if you agree to some sort of carve out, you may suddenly find that this attorney that's negotiating for the debtor may suddenly start making a lot of big concessions that are really beneficial to you as the secured creditor. So some people could say, well, you're just paying them off, right? The debtor's attorney is just selling their client out for cash. I mean, that's kind of a bad way to look at it, but that, I think, in a certain sense may happen in that they say, okay, I've got my carve out. Yeah, sure, I see that you're asking for the kitchen sink, but guess what? Yeah, it's allowed by the code, so yes, I'll agree to it. All right. Again, that's a key strategy to think about. Do you give up a little bit of cash to the opposing debtor's attorney, and what do you get in exchange? If you get some incredibly good protections and benefits, it may very well be worth it, because if it speeds confirmation of the plan along, sheds unsecured debt, you could have a loan that emerges that's going to be much stronger and better to work with. Another issue I've put down there at the bottom of the page is the 1111B election. The 1111B election is really where you have an undersecured loan, and basically the creditor asserts it, and then the debtor has to treat it as a fully secured loan but without interest, but it has to be paid out. There's some real strategy in using that. If you're in a real adversarial situation, it may be ripe to do that. we've got these key objections, and I know we're into the Q&A time. I see that we've got various questions that have come in, so I need to just quickly jump through this. You can challenge disposable income. I think that is going to be a real issue, a real sore point for contention when you look at these Chapter 11 cases. Some related issues to that is, what if the debtor wants to essentially save up, basically do a capital account to maybe buy something big down the road? Well, what are they doing that at the expense of paying income to creditors? So that's going to be a sore point. Another real sore point, and this is going to be a big issue, is what if you have an LLC that's a pass-through entity for tax purposes? Obviously, the creditors want to keep that cash in the company to pay creditor debt. The business owner wants to get the cash to pass through to him or herself to pay their tax obligation. That's going to be a big point of contention, maybe gives you some leverage points there. You can challenge the debtor's ability to make payments under the plan. You want to make sure that the plan has appropriate remedies in case of a default. You know, if it's an unfair discrimination, that's another basis to object to the plan. And then on this final slide here, other objections that creditors could raise would be that it doesn't fairly and equitably treat creditors, it doesn't properly pay the lender or treat or account for its lien. What do I mean by that? Sometimes, I think, especially you'll see this in Chapter 13 situations, they'll essentially front load the plan so that all the administrative expenses get paid first, and then the other debts, including the secured lender's debt, gets paid over a more extended period of time. Obviously, if I'm the secured lender, I don't like that. You know, why should somebody get paid an admin claim when it's really coming from my collateral? So, there's a bit of a give and take. Judges will approve something that's reasonable. Just want to make sure that it's not just really loaded to pay off all admin claims at the expense of everybody else. So those are some key issues to keep in mind. All right, so now that I've essentially chewed up through the Q&A time, let's turn to the Q&A. We've had some questions come in, and we'll take these the questions that have come in. The first question is, can you give examples of single asset entities? Hotels, yes, that's an example. Restaurants would be another example. Shopping centers, yes. You just need to think of what is a situation where, put the word in there, single asset real estate that's being used for commercial purposes. The next question that is coming in, it says on the slide on the 1191, what if one class but not all classes accept? If in order to get 1191A confirmation, you need 100% of the classes accepting. And that's a key point. So you need unanimity. Everybody needs to be on board to get 1191A. And so that's going to raise an interesting issue. What's going to be the role of the Chapter 11 trustee in brokering a deal? As a secured creditor, a key issue you need to be asking is, how important is it that I get 1191A confirmation? Depending on the debtor, depending on their history, depending on the assets that are involved, it may be really important. And so you may need to make some compromises to get there. I realize from a bank's perspective, that's really hard because banks typically have their own internal regulations. They don't, want to impair the loan in any way that they don't have to. And so you get kind of this collision of the regulations and the procedures at the bank versus what's possible in the Bankruptcy Code, and then trying to marry up or reconcile the two to get some sort of adequate resolution can be difficult. Another question. Another question we had was, again, just along the lines of 1191A versus 1191B. Yana, I'm basically at the end of our hour, and I know I've taken quite a bit of time here rambling on. Do you have any additional points before we wrap this one up?
I don't really. I think you covered most of it, so I have nothing else to add. I maybe answer one more question that came from the audience. if the debtor has 3 to 5 years to pay planned debts and are not discharging until planned payments are paid, are they in bankruptcy for the 3 to 5 years? The debtor will be in bankruptcy technically. The debtor will receive a discharge and the case will be closed once all planned payments have been made. Michael, I don't know if you have anything else to add to that.
No, I agree with that. And everyone, I guess just in conclusion, we thank you very much for your listening and your participation today. I know it feels like we've fed you with the fire hose. There's a lot here. Obviously, if you have any follow-up questions, feel free to reach out to Yana or myself. We're more than happy to continue this discussion with you offline. We hope that today this has been helpful for you. And just as a reminder, this program has been approved for legal education hours. So to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs, and we really do pay attention to that. So again, thank you very much for your time and attention today. This concludes our webinar. Thank you.